Good afternoon, everyone, and welcome back to JEI Week 2024. It is my esteemed pleasure this afternoon to introduce to you the Honorable Justice Alice Yorke-Soo, President of the Court of Appeal of Trinidad and Tobago, who is going to lead us in a very exciting presentation on judgment writing in criminal cases, extempore judgments, and summations. So I'll now like to hand over immediately to President Suhon. The program and her full bio will be shared with you in the chat. Good afternoon, President Suhon.
Good afternoon, and thank you, Antonio. Just for one, Super the Town, President of the Court of Appeal of Turks and Caicos, but not Trinidad.
My apologies, President of the Court of Appeal of the Turks and Caicos Islands.
Thank you. So, good afternoon, everyone. I am going to attempt to do 3 important topics in just an hour and a half. And so I will be moving on quickly, and I ask that questions be saved to the end of the presentation. Just take a note of your questions at the end of the presentation. I will be happy to address them. The first topic is that of extempore judgments. And what really is an extempore judgment? It is a judgment, as we all know, that comes at the end of the hearing of the case itself. And that is, of course, opposed to a reserved judgment, which is given sometime after the hearing. So the extempore judgment is delivered at the end of the date and time of the hearing. When should an extempore judgment be given? Usually it is given in urgent cases. Sometimes they're cases of public importance that desire an urgent decision. And so that would be a good opportunity to deliver an extempore judgment. It is also delivered in simple cases, cases in which everyone knows sometimes what the result might be. And so it is easy to give an extempore judgment in a simple case. But most importantly, it is given when you, the judicial officer, when you are well prepared and when you know your case inside out, when you're familiar with all of the material, and when you are confident about the outcome. So preparation is the key to the giving of an extempore judgment. When not to give an extempore judgment? Extempore judgments ought not to be given in complicated cases, in cases where the issues are somewhat complex, in cases in which there are fine analyses of law to be thrashed out and to be unraveled by the judicial officer, and there are complicated issues of evidence. In such a case, you ought not to give an extempore judgment, but take time to do all the unraveling. It is not to be given, of course, if you are not adequately prepared to deliver the reasons. And if you're not adequately prepared to deliver reasons, then clearly you would not be confident about the right outcome of the case. There are 3 main benefits of delivering extempore judgments. Firstly, it reduces delay. And of course, it reduces for the judicial officer, it brings his pile of writing judgments down. It reduces the amount of work he has to do. It saves time, and it also saves expense because the litigant doesn't have to come back to court and pay his lawyer another fee just to take the decision. And thirdly, it brings proceedings to a finality in quick time. And so these are the main and most important benefits of doing extempore judgments. Now, I want to suggest to us all a structure that we can probably, if you find favor with it, you can probably adopt in the preparation of an extempore judgment. Firstly, briefly set out, and please note the relevant facts of the case. Relevant is important because that is only the material you require in order to come to your decision. Briefly state the law, the relevant, and again, the word relevant is important here. Briefly state the relevant law. Then apply your mind to the law and to the facts of the case and apply the law and see what is the result. Having done so, you will be now in a position to list your reasons. So having regard to my findings above, these are my reasons for my decision. 1, 2, 3, 4. Bullet points are quite useful and you may wish to adopt them. And then finally, my decision is, or the outcome of this case is, or I hold so and so, or I find so and so, etc. So this is just a very brief and short way of dealing with an extempore judgment, and I commend it to you. It works very well for me, and I commend it to you. Now, the big question that often arises when dealing with extempore judgments is whether or not we can, when we receive the transcripts later on, can we reread the transcripts and make alterations to the judgment? And in looking at this point, I came across a very interesting article by Lord Neuberger at the annual conference of the Supreme Court of New South Wales, Sydney, Australia, in August 2014, in a lecture delivered by His Lordship on the topic Sausage and the Judicial Process, the Limits of Transparency. And he had this to say: I have rewritten sentences, even paragraphs. I have transposed paragraphs or even whole sections. I have deleted sentences or paragraphs, sometimes because I simply could not understand what I had been trying to say. End of quote. When I read that, I thought to myself, oh my word, what a confession of the learned judge. And I just want to go on to what more was said. He went on to say, once I added a paragraph because a brilliant new reason had occurred to justify my decision. In due course, my decision was overturned, and the Court of Appeal said my new point was a particularly bad one, showing that cheats do not prosper. End of quote. Now, it is obvious that rewriting a judgment in order to add new points, in order to virtually put in information that the parties did not have before the time of giving the extempore judgment will work to a disadvantage to the litigants in question, simply because they might have filed the appeal and not realized that this point was going to come up. And so they would not have included it in their grounds of appeal, perhaps. And so editing and altering extempore judgments are allowed, but only to a limited extent. And that limited extent is to correct typos, to change grammar, but rewriting paragraphs and adding new points are simply not allowed. We cannot seek, after we have given the judgment, to try to ensure that the appeal is in order, that it is appeal proof, as it were. We cannot do that. And so we must limit our corrections basically to rewriting some sentences, rephrasing them, perhaps in a way, of course, that it would not change the tenor and the final determination of the matter. Typos and grammar, of course, would be allowed. And then fairness. Extempore judgments lead to fairness in many different ways. Fairness because the judgment, fairness if the judgment, of course, is clear, transparent, and it gives a good accountability of the judicial officer. Clarity. We must use simple and clear language, nothing complex, not too much law, not too many quotes, just very clear and simple so that everyone, the litigant and the man in the street, can understand exactly what we meant to convey. Transparency, because as we all know, criminal trials are part of the public's business. And there too, the general public wants to know exactly how the judge came to his conclusion, and they want to know how and they want to know why. And so our judgments must be transparent. Accountability, meaning that again, we are accountable for the decisions that we make. And extempore judgments augurs well for the efficiency of the criminal justice system, where we can show that we are up, that we are in charge, we are in control of what we do, we know what we are about, we have the confidence in the case before us, we have well prepared it, and so we can deliver the judgment at the date of the hearing, or in a timely fashion when dealing with simple cases and the like that I've already discussed. So these briefly are the points I wish to share with you with respect to extempore judgments. And I will move on now to the next part of this presentation, which is general principles of judgment writing in criminal cases. So let me just stop share. Let me get hold of my next. Are you seeing my screen?
Yes, we are, President.
Maybe I could just. Okay. All right. So we're talking about the general principles in judgment writing in respect of criminal cases. Now, when we write judgments in criminal cases, and I'm speaking particularly in this presentation to trial judges in the criminal courts who hear matters sitting alone without a jury. And so when we write judgments, who are we writing for? Who is our audience? Are we writing for? Well, the High Court of Appeal will have to consider whether they're writing for the Privy Council. But trial judges, are you writing for the Court of Appeal? Are you writing for the parties? Or are you writing for the public, whom, as I have already said, hold an interest in criminal matters? Well, I want to suggest very briefly that we write for the parties. We also write to make sure we have the law right. So we write for the Court of Appeal. And also we write for the public who has a vested interest. And so we must keep all the participants in mind when we write. the Court of Appeal, the parties, and of course, the public. In the Turks and Caicos Islands, as well as in all the jurisdictions in the region, which subscribe to judge-alone trials, judges are mandated to give reasons. And so in the Turks and Caicos, you're familiar, I'm sure, with it, with Section 62(3) of the Criminal Procedure Ordinance that mandates the court to give judgment which state reasons for conviction. Now, it's a little peculiar how this section is phrased, because in most jurisdictions, for example, in Trinidad and Tobago, in Antigua and Barbuda, etc., in Belize, etc., the section, this similar section would say something like the court is required to give reasons in writing. But I suppose by saying you give judgment which state reasons means that it is in writing. So just a tiny observation there as we move on. So it's the duty of the judge to give reasons. The purpose of the reasons are threefold. One, to tell the parties why the decision was made. Two, to provide public accountability of judicial decisions, and we've mentioned that more than once. And three, reasons permit effective appellate review. When reasons are well written, trial judges have no reason to fear the Court of Appeal if your reasons are well written, well prepared. Now let us look at some essential elements of a good judgment. Clarity and precision, and I will be emphasizing clarity and precision as we go along, because clarity is extremely important, precision also important. No need for me, I'm speaking to lawyers, I'm speaking to judges, for me to explain what clarity means. The judgment must be intelligible and logical in reason. We must avoid complex sentences, strange or difficult words. Writing a judgment is not an opportunity to impress. It's not an opportunity for anyone to see how much we know and how well we can express ourselves. Avoid the use of personal experience. And that is very important. I've seen judgments where judges have said, well, I did so and so, I used to do so and so, and when I did it that way, and I find it very efficient, so I'm applying those principles here. That is not allowed. Your findings and your directions must be clear and specific, and your entire judgment must be cohesive, not repeating over and over, not caught up in minute details. It should not contain rambling dissertations of law, only law that is relevant. But it should be sharp and precise and clear and cohesive, with only the sufficient level of detail. Let's look at our approach. How do we approach our writing? Some of us like to take it argument by argument. Some of us in the Court of Appeal like to go ground by ground. Some of us choose to deal with the issues, issue by issue. And some of us mix and match. You might have a particular preference, but the trend nowadays is to take the issue by issue approach or the mix and match approach. You can choose which approach you adopt and which approach you use, and once it's working well for you, once it meets the requirement of a good judgment, it's cohesive, it's clear, it's precise, and so on, then you can stick to whatever approach suits you best. Now, we all have our different styles of writing, each one of us. But judgment writing requires that certain particular requirements be followed. And in that light, I would just like to share with you a suggested structural format for writing your judgment. The basic format should seek to include a summary of both cases in very broad terms. You need to set out the substantive law, identify the issues which are not in dispute, identify the issues which are in dispute, apply, if necessary, care and caution warnings, state how factual issues in dispute have been resolved with clear, succinct, substantiating reasons, apply facts as found to the relevant law, and then deliver your verdict. This is a basic format. You can adopt it as you see fit, if you find favor with it, and it works. Something that I use, and I find that it works when you have a format, you have a structure that you're following. It's very difficult to go off course in those circumstances. Now, what should be included in your judgment? All the material that would be relevant to the decision, anything that would influence the decision, all the information which bears on the issues, and anything you think perhaps the Court of Appeal might be curious about. So, for example, there may be a situation in which you need to explain why a witness said something. Maybe there was something that happened before, so you need to probably explain that in your judgment. What do you exclude? Well, everything else. Simply everything else. Information that has no bearing on the issues, irrelevancies. We see that all the time in the Court of Appeal, repeated information, phrases and language and so, but, you know, very often are put in just to impress, but really has no relevance and no bearing on what the issues are. So please be very careful about repeating information, putting in information that is irrelevant, information that has no bearing on the issues. Now let's look at some rules regarding the approach to the evidence. Not every failure to address every little issue in the case will render the judgment inadequate. Once the issue does not bear upon or is not too important to the outcome, then the failure to address it ought not to be a reason to overturn the judgment. Reasons must show the parties and the Court of Appeal the basis upon which the judge had actually arrived at the decision. Reasons must, of course, be applicable to principles of law. You must be able to identify those principles of law and the findings of fact. But most important are numbers 4 and 5. Yes, you need a statement of principles of the law. Yes, you need that law to be applied to the findings of fact. But what is most important and what very often seems to be missing from judgments is the reasoning process, linking them and justifying the outcome, justifying your final position. So your reasoning process is extremely important, and that must be revealed. Not only just a bare statement of the law or a statement of your findings of fact, but the reasoning process behind it. Now, very briefly, and I know that you're all familiar with this already, but your criminal judgment ought to contain certain factors. And of course, we know that these are just the general principles. You must mention and you must say that you have taken note of the onus and the burden of proof, the standard of proof, simple general principles, but if you do not say them in your judgment, and a ground of appeal is that you did not apply the proper standard of proof in your in your decision, then we would have to take a second look at it. So the presumption of innocence, where reverse burden occurs, you must address it. Inferences, matters dealing with several defendants, say that you have given them separate consideration. Expert evidence, if issues arise out of expert evidence, you must say how that you have determined the facts according to the evidence and show that in a logical and rational manner. Your duty, of course, is to determine the reliability of the witnesses. And when we speak of reliability of witnesses, I go on to number 12, which is unravel the factual complexity. Don't just say, well, I prefer witness A to witness B because I find him reliable. That will not do. You have to say why. Verdicts, you must show the options and why you choose one option as against the other. If it's evidence by audio video link, you must then explain the value of cross-examination and what weight you would have placed on that type of evidence. So these are just some general things that you must address in your judgment so that we see that you have taken these factors into account. Now, quotes. Now, some long quotes are most times not really the best. But there are times when there's good reason and you need to quote an entire passage out of perhaps a statute or a precedent, as the case may be. It is advisable that when we do that we write a summary in our own words of the value of using that particular passage and the inference that we expect the reader to draw from it, and then set it out so that, you know, if the reader skips over the whole thing, the reader would know in any event what was the value of that particular passage. Sentence construction. A common problem is poorly constructed sentences. Some people feel that long sentences are best, and that may be so. A long sentence with a huge number of words, once it's properly constructed and perfectly readable, that's fine. But there may be short sentences that could be quite confusing. Some of them can be poorly structured or laden with a lot of jargon and makes absolutely no sense. If you find a long sentence is suspicious, then take your time and divide it into smaller ones, making it more comprehensive. The use of legalese. We like to use our legal language. We like to show how much we know. That's all well and good. But if those could be avoided, technical language, foreign language, legalistic words. There used to be a time that judgments almost invariably contained Latin. The use of Latin phrases and sentences and so on. I'm really happy to see that there are few judgments now in which you will see Latin being quoted. And so as a student growing up, I used to find that very uncomfortable because I used to have to now go and look up these Latin phrases and try to figure them out and so on. But thankfully, we are past that and we now in the use of the ordinary English language. Remember to make your language simple. Remember to make it uncomplicated. Remember to leave out all these legalistic terms if they are not relevant. There are times you may need to use it, but use it in a way that the reader can well understand. I read something in a case years ago, again as a student, and it stayed with me throughout my legal life. I can't remember who said it. It may have been Lord Dippler, but it went like this. Brevity and simplicity are the handmaidens of justice, but length and complexity its enemies. And I found that very, very useful in my own career as both an attorney and as a judge. The simple message, keep it simple, keep it short. Let's look quickly at some important points to remember. Be precise and to the point. Be coherent, sorry. Use footnotes where necessary in order to avoid clutter. Now, there's another view to that. Some writers do not like footnotes at all and think that if you don't need, if you need to include the information on a footnote, it should be part of your writing and not just something to cast an eye on. But it is a matter for you. You can choose if you find it necessary to use them when necessary. Avoid quoting a whole list of authorities which make the same point. Just use the landmark decisions. And again, you might want to refer to the others in your footnotes. You may simply want to leave them out. Only details that are relevant to the analysis should be included. And of course, we need to omit everything else. Let's look now at what our reasons should contain. And again, these are only my suggestions. You are free to accept or to reject. Let us first begin by identifying what the crucial issues are. Once we have those clearly in mind, I suggest it could be fairly smooth sailing. Then we summarize those crucial arguments. We explain how we have dealt with those arguments. And now, having explained that, we can then move on to see how we resolve them. Provide a rational and considered basis for your conclusion reached. And avoid conclusionary credibility preferences. I think I dealt with that a minute ago when we spoke about preferring one witness above another. Just saying I prefer X. X was a credible witness. His demeanor was good in the witness box. And I think he was speaking the truth as opposed to everyone else. So I accept him, and it's on the basis of his credibility I have determined this case. That is not allowed. Just go into the aspects of his credibility and see why it is that you have accepted his evidence above the others. Now, to what extent must we dive into credibility assessments? Now, the assessment of credibility is an essential aspect of the fact-finding process that we are required to conduct when sitting alone in a judge-alone trial. And so it is important to demonstrate in our reasons how we assess that credibility. The Court of Appeal, in discharging its function of review, must have regard to factual credibility findings made by the trial court. And very often, the Court of Appeal will not interfere with findings of facts and findings of credibility made by the trial judge during the trial, except, of course, and I'm sure you know all the exceptions that are found in the case of Beacon and so on, all the exceptions, unless it was, clearly wrong and so on. So our findings of fact sitting at the trial court are very important to the Court of Appeal. So this is why we must express them clearly. Now, to what extent, again, we continue to look at the extent at which we delve into the credibility. And we have all our tools in order to assist us in dealing with credibility and evaluating credibility. And we know what they are. We look for the consistencies, the contradictions, the inconsistencies, internally, externally. We look at the plausibility of the various accounts. We look at the demeanor of witnesses, and demeanor is a very big area, very contentious area. Hope we had, hope that sometime we get a chance to look into this whole area of how we assess the credibility of witnesses. We look, of course, sometimes, if relevant, at the motives. And so these are the tools we have in order to assess credibility, and we must use these tools to assist us in coming to correct decisions in respect of credibility. Now, what if the case is a case of circumstantial evidence? How do we approach it? The judge sitting alone must examine the strands of the circumstantial evidence upon which the prosecution relies and decide whether the judge can accept or not accept that perspective of the evidence as he or she's been asked to do by the prosecution. And the judge at the end of the day must come to fair and reasonable conclusions based upon this circumstantial evidence. Of course, the judge must remind himself not to speculate and must draw conclusions beyond reasonable doubt. If they're conclusions of equal weight, then it would mean that the prosecution might have failed to prove its case. So in respect of circumstantial evidence, if it is a case of circumstantial evidence, be careful to include in your reasons how you have dealt with the circumstantial evidence. That's very, very important. Reasons should contain warnings and principles of law relied upon. I find this quote taken from Justice of Appeal Rowe from a case in the Cayman Islands called Richard and the Queen, 2001. Very, very helpful. And if you would permit me, I would like quickly to just read the quote. A trial judge sitting alone has advised himself to the applicable principles of law and given himself the necessary warning. He must indicate clearly in his judgment his reasons for acting as he did in order to demonstrate that he has acted with the requisite degree of caution in mind and has therefore not heeded his own his own warning. No specific form of words is necessary for this demonstration. What is necessary, however, is that the judge's mind upon the matter should be clearly revealed. End of quote. To sum it up, if it is not there in your judgment, we take it in the Court of Appeal as if you have not said it. So please do not say, well, I took the warning in mind, I cautioned myself appropriately, but if it's not there, it's not there. So please factor it into your reasoning, if applicable. Another area that we must look at and factor in our reasons in is the whole Turnbull position. The warnings must be included in your reasons, because you remember, one thing we must not lose sight of sitting as a judge in a criminal trial without a jury is that the judge now sits as both judge and jury. So the same warnings that would apply to any jury on the issues which arise in any particular case would be the same warnings that will apply to us sitting alone. So consider that the evidences are not supported. Consider that honest witnesses make mistakes. Consider that there are actual weaknesses in the evidence or potential weaknesses. Consider if it's a case of recognition, that we can sometimes fail to recognize people we know for a long time, etc. You know what they are. All I'm saying is that we need to be careful to take these warnings in mind and to factor them into our reasoning. See the Jamaican case of Barrington and Taylor. Now, care and caution warnings must include justification for either giving a moderate or strong care and caution warning. We all familiar, I'm sure, with the discretionary warning contained in the case of Macanjola and Easter 1995. And so we need to say why we're giving ourselves a moderate warning, why we choose to give ourselves a stronger warning, or why it is that we choose not to give ourselves any warning at all. And so that is important. And remember, particularly in sexual offenses cases and so on, that you must, if it arises, you must see how you approached it. Remember also, most importantly, that there will need to be an evidential basis for suggesting that the evidence of the witness may be unreliable. There must be an evidential basis, and you must point out that evidence in your reasons if you so. Now, what about care on caution warnings and the extent to which we must refer to them? The case of Fleming and the Queen states that I just find it very apt. The requirement to take a warning into account necessitates that the judge expressly refer to the warning in his or her reasons for judgment. Again, if it's not there, it's not there. Reasons must include, where necessary, an accomplice warning and an assessment of the credibility of that witness if he's an accomplice. So the assessment of the credibility of an accomplice involves a very stringent scrutiny as opposed to an ordinary witness, or as opposed to a witness with an interest to sue. And it must therefore be a more robust type of warning. For an example of such warnings, I've referred you to the Victorian Criminal Charge Book and the Trinidad and Tobago Criminal Bench Book, where you can find the nature and content of such a warning. But remember, when you deal with accomplices, you are dealing with an assessment of their credibility. And so you may need to give yourself a more robust warning. And that is a less robust warning than if you're dealing simply with a witness with interest to sue. And so they're two distinct situations. And so you can look at the examples that I have reviewed for further assistance. In sexual offenses, let's be careful about the stereotyping and refer to them in our reasons that we have appropriately directed ourselves on all the types of stereotyping that can arise in sexual offenses, and I've listed some of them there for ease of convenience. Reasons should include good character directions and demonstrate how they are factored into account. Now, this area of the law has grown in complexity over the last 2 decades. But I want to recommend to you, and I'm sure you know it already, the case of the Queen and Hunter, which reviewed Aziz and Vi and all the other cases that came along. A very, very comprehensive review of all the cases concerning good character, and it settles the point of good character very well. A judge, the simple point I want to make here without going into the complexities of the different considerations in Hunter is simply that a judge sitting alone in appropriate cases must take into consideration the accuser's good character when it arises. So please bear that in mind, and of course, remember to put it in your reasons. Provocation is another area in which good character arises, because when a person is of good character, the judge must direct himself that a man of good character might have been unlikely to indulge in very serious violence without first being provoked. See the case of Bimal Roy Parry, a case from the Privy Council on that point. So provocation and good character. Remember to factor in the provocation, good character when deciding on the provocation. Remember to put it in your reasons. So I just think I went backwards. Bad character. Similarly with bad character, previous convictions, striking similarity evidence, what we knew before, similar fact evidence, imputation, character, prosecution, witnesses, and so on. If this arises, you need again to see in your reasons exactly how you have dealt with it. Now, in closing, just to summarize, I've given you a format and some rules of how a judgment should be written in a criminal case. And I have pointed out some areas that you should be careful about when writing a criminal judgment, remembering to factor in your reasons and making specific references to areas such as identification, sexual offenses, and so on. So I have come to the end of this part of my presentation, the second part of it. And again, I ask you kindly to hold your questions towards the end of our session. Thank you for your patience so far with me. Let me just fetch my other presentation, which will be the last one. Okay, are you all seeing my screen?
Yes, we are, President.
Okay, thank you very much. Okay, so we're going to be talking about the summation itself, and this is jury directions, a practical guide to jury directions. And my theme for this presentation is it must make sense. This is a time in which we are dealing with lay people, and it must make sense to us before it makes sense to them. So bear that in mind as we go through. It must make sense. Now, everyone has their own particular styles. And lately, we have seen a lot of skills and a lot of demonstration about styles. If you looked at the latest presidential debate, you will see that, you know, both candidates had their own styles of trying to convince the public that they should get that vote. And of course, our leadership has their own style. The gentleman in the middle has many styles. I'm still trying to figure which one I should acclaim to him. And of course, the president of the CCG has his own quiet style. So we need to develop our own styles when speaking to jurors, and I'm sure some of you have already done that. Now, we will develop our style depending on a number of factors, one of them being, again, our audience and our purpose. Are we speaking, when we speak to jurors, are we speaking with the court of appeal in mind, making sure we get it right at all costs, spelling out tons of law that the poor lay people cannot grapple with? Are we trying to reach the entire panel? Are we trying to reach particular jurors? Are we trying to reach Mr. John public? So the same issues arise in our speaking as it does in our writing. Now, in developing our style of communication, it will automatically be dependent on the target audience. How do we speak to the jurors? Do we just prepare everything in writing and just read to them? Do we speak and then lift our heads up and give a sort of summary of what we just said? Do we read from the texts, or do we take it all from the top of our heads? I would urge us all not to follow the top of the head approach, because that's clearly a recipe for mistakes, a recipe for making errors. Some of us know it all, and I don't begrudge anyone who thinks that he knows it all or she knows it all. That's fine. But if you do know it all, make sure when you speak at it from the top of your head that it is mistake proof. Some communication factors we should bear in mind is the body language. Our own body language speaks volumes. So if a witness is given evidence and the judge keeps rolling up his or her eyes up into the ceiling, then that might convey a certain impression to the jurors that the judge is not happy with this witness. The judge doesn't believe this witness. So we have to watch our own body language. Our speech and our language to the jurors must be clear and concise. We mustn't keep repeating the same thing over and over. We must watch our tone and our volume. And of course, we come back down to simple language. There was a judge when I used to practice who had a particular tone that he used whenever he wanted a conviction. He used to say to the jurors something like this: Mr. Foreman, members of the jury, the accused has said that he was not there, that he did not commit this offense. I don't know if you believe that, but it is all a matter for you. By that tone, he was actually conveying to the jurors that what the accuser's defense was totally unbelievable. And so very often he got the desired result. That, of course, is not allowed. So let's watch our tone and our volume. Attentiveness. Pay attention to the jurors. Observe them. Because when you observe them, you can gauge whether or not you are actually reaching them. You are actually making sense to them. Sometimes they may require a further explanation. And by just gauging them, you will be able to tell, and you can then assist them in that regard. Now, when do we begin our summing up? Do we begin summings up when we have finished with the evidence at whatever time of the day? Should we come back the next day, or should we begin right away? Should we come back a couple of days later? Well, if it's a very complex case, when all the addresses are in, you may want to take a day or two at most to go over your notes and to make sure that you're all prepared to fine tune and recheck matters that you feel you need to address. And so I have no problem with judges taking a day or two, but it should not be any length of time, 2 weeks, 3 weeks. We are way, that is way overdone. If you finish late in the afternoon, well then let the jurors come back early in the morning. They've just heard counsel. It may also be a day in which evidence had to be wrapped up. So let them come back early the next morning when they are fresh, and you too are fresh. And it will also give you an opportunity overnight to make some final checks. Now, during the course of the summation, how do you take your breaks? Is it after you finish a particular issue? Is it when you've reached a certain point, you think they've had enough, or do other circumstances intervene? For example, one of the jurors need to take a bathroom break. These are all things that you have to think about, and you should have a particular pattern of operation. It makes it very easy when everyone can prejudge what the next move of the judge is in these simple matters. When do you end? If you have to continue a summing up for another day, when do you end? Do you end at the end of the day and come back the next day? Or do you go late into the evening and allow them to deliberate that very evening? What do you do? These are all things that you need to do. You need to think about and need to have a plan for, bearing in mind, of course, the jurors are just like us, ordinary human beings. They have their concerns, they have their family lives. Some want to go home and get homework done with their children and their other domestic responsibilities. And so we must bear all of that in mind and, you know, have a plan as to how we are going to approach these, what may seem minor issues. Now, preparation of the seminar. We need to maintain a checklist, have a checklist of the things as the case progresses, have a checklist of the things we need to address. Draft as the trial progresses. Do not wait until the trial is completed to begin to draft your seminar. From day one, as issues arise, inconsistencies come out, make a note, begin to draft from the very beginning. When you do that, you will be giving yourself time to think about it carefully, or to perhaps discuss it with other fellow judges. Begin to make a summary of the evidence and begin to take a note of the points that you wish counsel's assistance on, and indicate to counsel that you would be needing an ENSO hearing so that they too can well prepare for such a hearing. So these are the points of preparation. And I want to suggest that they go very far, and I commend them to you. Now, summing up on a checklist. We spoke about that just a minute ago. These are the general things that you should concern yourself about, the general type of direction. The functions of the judge and jury, burden of proof, separate treatment if there are more than one accused. And of course, you'd recall that these are the same things that we will be addressing when we write a judgment as well. Defenses, joint responsibility, things like that. So these are some regular areas, general areas that are often addressed. So these are all listed here. And on the next slide, I put some various aspects of the evidence which may lead the trial judge to look at specific areas. So circumstantial evidence might arise, good character, bad character, accomplice. Make a note during your preparation time so that you can come back to it and address it. Lies, identification. These are all things which arise during the course of a criminal trial, issues which arise and which need to be addressed by the trial judge. Some summing up points. Again, length, length, and repetition. Not unnecessarily long and repetitive. That point was made by the Privy Council in the case of Castle and others. A summing up should not be long and repetitive. Be careful where there's a special plea, like, for example, self-defense. Remember the onus of proof and so on. If issues are simple and the case is short, you do not have to review the evidence. There's no obligation to review the evidence at all. The case is short, it's simple, the jury just heard it. Let's credit them with some good common sense, and we do not need to repeat it. If we do need to touch upon the evidence, it will just be the major aspects of it. Remember always to put the defense fairly and adequately. That's a ground of appeal in my 16 years of the Court of Appeal that I have seen over and over. Almost in every appeal, the defense was not put fairly and adequately by the judge. And so I urge you to pay attention to the defense. The judge is entitled to comment on the facts, but your comments can't be at large. Your comments must be on the facts and within your crease. The case of Brown and Outram deals with that point. Judicial comments must not be adverse to the accused. Remember, fairness, fairness, fairness is the key word, the watchword in all criminal trials, being fair to the accused. Under no circumstances, counsel should interrupt the judge in his summation. Time for doing that is at the end after the seminar. Put the jury out and ask counsel, is there anything that you wish to raise that I have not addressed, and you ask the jury to go out, you say, members of the jury, we just want to have a quick, I just want to have a quick word with counsel concerning matters of law. Would you step out of court for a moment? And then they come back in and you continue. You have your quick word with counsel on both sides. But it's very, I'm sure you find it very, very, you know, distressing when counsel jumps up during the course of your summation and seeks to make a point. So at the very start, let counsel know anything you wish to address me on. Please do it when I'm finished. Now, if there's an error in the prosecution, in the summing up, the prosecutor knows his duty. I would assume that he has to assist the court in unraveling and correcting that error. And under these circumstances, of course, should you have a jury return a verdict of guilty, we cannot direct them to return a verdict of guilty. Be very careful about that. Now, how do we approach the law? There are two fundamental factors that we need to take into account. And in the case of Keene and another, those two factors were made quite clear. The first is that we need not trouble the jury with aspects of general law which do not arise on the facts of the case and on the issues raised by the evidence. I can summarize that as relevance. We do not trouble the jury with anything that is irrelevant. And secondly, we need to apply the law to competing versions of fact. The accuser is saying this, the prosecution is saying that. What is the law and how does this apply? If you accept one version or the other, how is it you how are you going to apply the law in relation to each aspect of the various of the two versions of the competing versions? So these are, as discussed in this case, the fundamental business of summing up is just relevance and application of the law to the competing facts. Now, every case has general directions of law, and we have already looked at that. And there are also specific directions if they arise in a particular case, for example, joint enterprise or good or bad character. Your directions must be in a rational order. You must organize your directions. Let one issue flow into the next, and create a logical sequence of how you address the issues. Avoid unnecessary directions. We have seen directions to jurors about circumstantial evidence quite frequently when it does not, when it is of no relevance, it doesn't arise. We've seen directions, inferences, when again, that issue does not arise. And so be very careful to avoid unnecessary directions. How do you deal with the evidence? Firstly, when you come to the evidence, tell the story. Each side has a story. Do not take out your notebook and read the evidence to the jury. Do not take it out and read the evidence and say, you remember when Mr. X was in the witness box, he said so. Let me refresh your memory. Mr. X said that on this day he was walking along Fraser Street and he saw so, and he did that. Reading from your notebooks, in my view, is simply not allowed. As the judge, you ought to know the case. You ought to know what the different stories are. Tell the story. Tell the prosecution story. Miss A said that on the so-and-so day of that, she was in so-and-so place when she accosted a good friend of hers, whom she knew for a long time, the accused so-and-so. He invited her out to a drink, one thing led to another, and so-and-so happened, he raped her. And then The accused, however, is saying on the other hand that he did meet Miss E on so and so day. They met in that place, they had drinks, they had a good time, and then she consented to sexual intercourse and so on. So that is his story. So very briefly, you have told both stories without using your notebook. You must know the case, tell the story, rehearse the evidence, only retell the relevant aspects of the evidence, and the story must include what the issues are in the case. My quick example showed that the issue was consent. He says she consented, she said she did not consent, etc. Now, very often we think that a short case will have the evidence will be short and the summary will be short. That may or may not be so, again, depending on the complexity of the case. A long case may give rise to a lot of evidence. The summary may be long, but it may not be so. The issues may be very, very narrow. And then you need to know how to place your law within the evidence. Perhaps you might want to intersperse it. So after you give the story of the prosecution and of the defense in that example, which I just gave, you may then want to go right into the law. The issue for your determination, members of the jury, is whether the virtual complainant consented to sexual intercourse with Mr. Y on the day in question. And then you may want to do the law because you've just given the facts, and then you will support it by the facts relied upon by the prosecution. And then at the same time, bearing fairness in mind, you may there wish to address the defense and the evidence relevant in support of the defense of the defendant and that in respect to the allegations. Be economical with your opinions, though you are allowed to give opinion evidence. So you will have to choose whether you will give all the law in one block or you would intersperse them. My suggestion is intersperse it with the issues, as I have just tried to outline, so that it makes sense. It makes more sense that way than giving them all the law en bloc, and then they come to try to figure out which piece they must apply and which they ought to leave behind. Now, assisting the jury. This is distinct from telling the jury what the law is, giving them a statement of law or reviewing the evidence with them. This is really a two-part exercise. Firstly, when you assist the jury, you are putting the evidence of the state and the accused in context, and you are identifying specific bits of the evidence that may be significant. And secondly, you're focusing on the fact-finding function. So it's a two-part exercise in assisting the jury. Put the evidence for both sides in context. Identify significant aspects of the evidence. And secondly, focus on the fact-finding exercise, the demeanor, the inconsistencies, etc., motive, perhaps, etc. So the fact-finding exercise will include consideration of all the fact-finding tools that we discussed earlier, warn of possible bias, tell them that motive to be truthful, tell them about deception, if necessary, if relevant. Explain the value of internal, external consistencies, and so on, depending on the relevance of these things to the case itself. Now, in concluding this aspect of the presentation, you look at possible verdicts. What are the possible verdicts? If it's a case of murder, you may have a possible verdict of manslaughter arising. If it's multiple counts, you need to direct the jury on each count, and they must know that they can find him guilty of one, as opposed to all, or as, you know, give them the variations. If it's multiple accused, they must consider each case separately, as they must in the case of each count, must be considered separately. Counsel in their addresses, closing addresses to the jury may raise certain points, and please bear those points in mind. Sometimes they are very important points and you can't incorporate them in your summation because if they're useful and important, they would be helpful. If you have made a mistake, you have had overnight, or you took a break during the summation, and you came to the conclusion that I made a mistake, I should not have said this, I give a wrong direction and joint responsibility, perhaps. You can formulate the correct direction, come back to the jury, tell them that you have made a mistake, and that you're now correcting it, that you want them to disabuse their minds of what you have told them earlier, and you are now correcting it. And this is how you'd like them now to see that point on the basis of this new direction. Some judges don't do that. They think that, judges don't make mistakes, and judges don't come to the ordinary lay people to say that I have made a mistake. That doesn't look good for the judiciary. Well, in my view, it looks very good. In my view, it elevates that person in my mind, because I think that he or she is doing an honorable thing, admitting a mistake and correcting it and avoiding, most importantly, miscarriage of justice and a delay, because that would be a good ground of appeal, and the matter has to swing all the way back to retrial in some cases, and someone has to be in jail while all of this happens. So in my view, it's a noble approach to adopt, and I highly recommend it. If you think you made a mistake, say so. Just say so. We are all humans, and mistakes are allowed. All right. In all of our jurisdictions, we have a time allowed for the jury to come back with their verdict, so that you will keep that in mind and let the jury know that after 3 hours, as the case may be, you will be sending for them. Now, 2 things out of the summation I would like to address, and one is that of written directions. Do you give written directions in certain cases to the jury? Anybody? Okay. Well, if you don't, I recommend it highly. Written directions are very useful. Useful, of course, but not in every case. In Belize, they gave no written directions. But recently I recommended, I hope they would adopt my recommendation. Written directions are not given in every case. Written directions are given after counsel both sides, consult with the judge as to what those directions will be, what they will contain. And they are given really in matters of substantial complexity and matters of in cases that are quite long, that have taken quite a bit of judicial time. And written directions are different from a written route to verdict, which we will talk about shortly. So written directions are given in cases that are complex. Listen to the complexity in this case of Green. Legal directions had to be given in relation to murder, manslaughter, robbery, joint enterprise, self-defense, lies, the rule against hearsay, a dying declaration, and good character. Now, if anything can be called complex, is this case of Green, with all those issues to be addressed. And the court found that it was regrettable that written directions were not given in this case to ordinary men and women who are trying to unravel and apply the law as they have been directed. So written directions can be very helpful in cases of substantial complexity. Written directions, when used, the jury should be informed that the document is not intended to be a replacement for the oral directions, but it is an addition to the directions given orally. And care should be taken that written directions are accurate, that they are absolutely correct without the possibility of any misunderstanding. And again, simplicity. The oral elaboration, elaborating them orally and explaining them to the jury, must not conflict with the written directions. We had a case in which it did. And of course, that was a good ground of appeal, because what the judge said orally conflicted with what was given in writing. And so that was no good. Now, written directions, the benefits of them, they improve the juror's comprehension of the case, reduces deliberation time, they assist in resolving disputes between jurors, they help in identifying the final issues in the trial. And those are just some of the benefits of written directions. If you don't do it in the ticks and kickers, I do urge you to please do so, to begin to use it. Route to verdict, we said, is different from written directions. Written directions is about the law. The route to the verdict really is, as it says, a route as to how to arrive at your verdict. Now, your directions to retire, and I'm sure you're familiar with this, must not put any pressure on the jurors. It must not give them the impression that the case is an open and shut case, and perhaps they need not retire. And so that problem was solved way back in 1999 in the case of Winston Solomon, where the Privy Council actually laid out for us, as I have laid out here for you, the proper direction that should be given to the jurors when they retire, which is that they be given the option of either retiring to consider their verdict or giving their verdict without retiring, and the option is given to a jury in every case, and they then ask after consultation what is their choice. Would they like to retire, or would they prefer to give a verdict without retiring? We spoke a little bit about late retirement in capital cases. In the case of Holden, the state, the Privy Council condemned the late retirement of the jury and said that that was undesirable and that it would be better to adjourn the matter and sum up afresh the next day, so as to avoid a late retirement. I come back now to the further directions. When a jury comes in for further directions, the judge ought to consult with the advocates, let them know what is being required by the jury, and the jury comes back in and the judge inquires in open court what is required. And if it is something the judge had already addressed, then he should repeat in the same terms, providing that his earlier direction is very comprehensible. He should now repeat in the same terms all that he had said earlier, and perhaps just breaking it down a little bit so that it becomes more comprehensive. But he shouldn't stray away too far from what he said earlier so as to avoid confusion. He should be very careful that there's a danger of confusion when he tries to repeat and go over what was said earlier. So he should try to avoid the confusion. Now, the route to the verdict sets out a logical sequence of questions which are framed and which address all the legal issues to be assessed by the jury in order to arrive at a verdict. And again, I don't know if you do route to verdicts, whether you assist the jury in the Turks and Caicos Islands by giving them a route to verdict. But I would be happy to provide some samples for you about how that is done, some samples about written directions, etc. So I have come to the end of my presentations. I would have realized each of them would require much more time to do some more details, but this is just to give you an overview of summation of extempore judgments and about writing judgments in criminal cases, sitting as judge alone. So I want to thank you for your kind attention and your patience. And now we have a few minutes, we can open up questions.
Thank you very much, President. We have about 8 minutes for any questions or comments, so please feel free to ask President any questions you may have. Thank you.
Do you do written directions in the Turks and Caicos route to verdict? Something on the chart. Any questions, anyone? Miss Ida, have been a very good presentation or a very bad one?
We have a question in the chat or comment from Justice Silochan. It's not something that seems to be done here from his short experience.
Okay,
That's in response to your query.
right. Thank you, Judge. If it's not done, I would encourage it in certain cases, of course, where the case is complex and the issues are long, etc. Thank you very much. Okay, Mills, thank you so much.
Right, so if there are no further questions or comments, I think we'll go directly into the formal vote of thanks. So I'd like to thank you, President Suhon, and I'd like to invite Ms. Tanya Carter, the Executive Director of the Office of the Chief Justice, to give us a formal vote of thanks. Before I hand over to Ms. Tanya Carter, I'd like to inform all our participants and attendees today that the recordings and the materials from this JEI Week seminar are available on our website, jei.tc. I'll share the link in the chat, and the website will be updated as soon as we have more materials coming in and as soon as the videos are processed and can be uploaded. So thank you very much for attending, and I now hand over to Ms. Tanya Carter.
Thank you, Antonio, and good afternoon, everyone. To Justice of Appeal Yorke-Soo, President of the Court of Appeal of the Turks and Caicos Islands, we wish to say thank you for your presentation on such an important topic, as a judiciary judgment writing is a crucial skill for judicial officers, as it enables them to clearly and comprehensively communicate their decisions for our judicial officers. And as you have stated in your presentation, good judgment writing is essential for ensuring transparency and consistency and fairness within the legal system, and it also serves as a record of the court's reasoning and conclusion, which is critical for attorneys and more so for the parties involved in the case. Your very thorough presentation and pointers were quite apt, and I am sure, no doubt, as we are seeing in the chat, the judicial officers and all present in attendance greatly appreciated the information that you shared on this afternoon. So once again, we say thank you very much for what was an excellent presentation, President.
Thank you so much, Tanya.
That being said, I now pass the buck back over to Antonio to close off day 4 of the JEI Week.
Thank you very much, Ms. Carter. So that brings today's presentation to an end. I'd like to thank everyone for attending day 4, and we hope you do join us tomorrow at day 5, which is the final day of JI week. I hope it was very enjoyable for everyone, and we look forward to your attendance tomorrow morning and tomorrow afternoon. So good afternoon, everyone. Thank you very much for attending JI week 2024.